Counsel, the legal brains behind PHMSA. And she's and she's going to try to, I got up and said what I thought, and Congress followed, and then the SDOs have weighed in, and it became apparent to me very early on it was a way more complicated subject than I ever realized it was. This is taken kind of place in a national discussion too that goes way beyond just these pipeline standards. There's university law professors around the country who have petitioned, I can't even remember who they petitioned, to open this up on a much broader scale. So this is all kind of going on in the context, and PHMSA has been caught in the middle of, okay, we've got 1 year to implement this. How are we going to do that? And that, I think, is what Vanessa is going to talk about right now. Up and down.
Thank you, Carl. A quick show of hands. I see many faces that I know in other contexts. How many of you participated in or watched the July 13th PHMSA webcast on IBR? Okay, so I'll tailor my comments just in the interest of time and to make sure that we have time for comments and questions. But PHMSA has a unique position because before, I guess, December, technically, and then January when the President signed the Pipeline Safety Act, a years-long project had already been underway trying to figure out how DOT as a whole, not just PHMSA, but all of its modes, could be much more transparent in getting standards out. We already had standards available in hard copy at regional offices or the headquarters, but one of our regulatory attorneys who has spent about just shy of 30 years doing administrative practice came up with the idea a year before Section 24 was even passed, because he said, there might be a better way with the information age for DOT to be a little bit more transparent, to have these standards more available, more widely available, because it's a twofold. It's not just to make sure that the public knows what these standards are, but it's to make sure that those who are governed by the law have access to it, and particularly if they're smaller. So that initiative was well underway. And then we were pushed to the fore because Section 24 was passed with a limited timeline, so we picked up the pace. I think we have identified several issues in trying to implement Section 24 because we want to balance the, I think, very valuable goal of transparency, openness, availability, both for the public and the regulated entities, but balancing that with many of the issues that we learned about as we began to dig into the best implementation strategy. And so what I'm going to focus on a little bit are the 6 or 7 issues that some we identified before, and others came to our attention as part of the July 13th forum, letters, and other feedback from stakeholders. So you've heard a little bit about the legal issues. I'm not going to drill too far into those because I think Carl and Helena did a great job outlining the intellectual property issues. One of the issues that I think goes under discussed is that there are secondary and tertiary references in these standards. So when we talk about the standards, what we are generally referring to are the primary standard that's incorporated into our regulations. But as many of you know, most of those standards will then send you to another standard within a standard or a tertiary standard within another standard. So it drills down pretty far. And the SDOs have done a great job, I think, in developing their own licensing arrangements with international bodies, other SDOs, and managing those license arrangements with anyone with whom they have a deal to incorporate those standards. And so when we started to pick this apart, one of the things that we were made aware of was, well, if any of the SDOs or if DOT, you post on your website these standards, have you gotten permission from the quasi-governmental, governmental, or private entities abroad because they are referenced as secondary or tertiary standards? And we said, well, that's a really good point. We didn't know that. I mean, we will talk about that. One of the other issues that was raised was SBIFRA, which is a federal statute that requires us to have plain language descriptions and plain language text, particularly for small business. And the question then became, well, if we had to incorporate these standards by cutting and pasting them or not using them and the government just started to write its own standards, would the regulations balloon to where they were 30, 40 years ago to very unmanageable, unwieldy, non-plain language summaries. And part of what I think is embedded in the NTTA and OMB circular that Carl and Helena mentioned was a goal to have more manageable regulations. It was to have these incorporated standards be a link that you could then go to, but it would allow both the regulated and those who are affected by the law be able to get a much more succinct version of what exactly was being asked of them, and then they could go to technical or non-technical standards. But you wouldn't have legal requirements that were thousands of pages and very difficult for people to wade through. And one of the concerns that was brought to our attention was if people have to dig through a code of federal regulations at two or three times the size it is today, will that actually undermine safety and undermine compliance? Because as they wade through it, do they get confused instead of getting the basic requirement and then being able to simply go out and get the technical standards that support that rule? So that was one of the other things that we learned. The legal issues kind of overlap with some of the other things I'm going to talk about in a moment, particularly the international and policy implications. But as we mentioned, there are two executive orders out that support OMB Circular A119 and the National Technology Transfer Act that promote international cooperation. So that we also have international treaties, and that's to promote some form of commonality among commerce and technical standards so that U.S. companies and particularly those that do business globally don't have to have U.S.-specific standards and then are in any way disadvantaged because the rest of the world is only doing one standard. So when we looked at some of the legal requirements, it started to focus our attention more broadly into international legal and policy or executive orders that weren't squarely IP or NTTAA, but they obviously had an impact because if we stopped using, let's say, an ASME or a NACE standard and the government created its own, we now begin to create a framework where we're not necessarily facilitating global commerce, we're creating different frameworks for companies to follow. So the financial issue arose as we were trying to figure out, well, maybe we can address the legal issues by licensing. And one of the things that we heard was it would cost hundreds of millions of dollars potentially to compensate SDOs who would post their standards on a website for free because they would lose market share. And some of these SDOs you've heard, they're not all created equally and they don't all have the same business model. And some of them have said to us, I get more money globally than I do than I do domestically. So if I post my standards for free and everyone can get them for free, I've lost sales. I've lost a global market potentially. And even if you wanted to license it from me, you couldn't spend $400 million. And then we said, well, that's a good point. Congress probably would not give us $400 million if that is your alleged licensing cost or the loss of your intellectual property. And when we started to peel back on that and other financial issues, what it would cost to hire a corrosion expert, a boiler pressure expert, a welding expert, a construction expert, and have the technical talent resident in PHMSA to then draft these standards and to have a framework to invite people in to give research, academic, and other input and host those meetings. We would be replicating the 65 standards, I think, that Carl put up, and about 20 or so SDO's business models. And the government would absorb that cost. Taxpayer dollars would absorb that. And that's not something that had been budgeted for. So we put the licensing aside and the cost of hiring effectively many SDO staff resources internally to replicate these standards and said, well, what else could we possibly do? Are there certain standards that there are alternative standards? And for some of these standards, as I think Helena mentioned, they've been around for 100 years and there really is no other replacement standard. It is the preeminent global standard and there wouldn't be another one for us to substitute if that SDO decided it was not going to post its standard on the web for free, according to Section 24. Another category of question that arose was some of the policy issues embedded in how we, DOT, would implement Section 24. And part of balancing the transparency in some of these legal issues was, well, we want to comply with Section 24 by January, but if we were to post these SDO's materials without their permission and say, well, it's part of the law now, so we're going to post, we didn't want to also be in the position where the federal government was actively or explicitly infringing upon intellectual property rights, because that's also a policy. That's a government policy issue. There are plenty of constitutional and statutory requirements that we can't just co-opt all of the SDO's intellectual property posted on the web under the, I think, legitimate reason of we're trying to comply with the statute, because nothing mandates that we must post these. It says if we're going to incorporate these standards, they have to be available for free on the internet. So we didn't really feel we had a legitimate argument to simply take the intellectual property and post without being subject to potential infringement claims. And then the other policy issue was we really wanted to implement Section 24 in a way that mirrored as closely as possible how the standards today are incorporated into the regulations. And by that I mean having them be made available, whether that was read-only or printable or downloadable, however the SDOs wanted to manage that, but in a comprehensive way and in a current way and hopefully accessible to all. And that led us into the disability community and how these might be made accessible to those who otherwise are used to having 508 compliance on a government website. I think the government, because of the American Disabilities Act, is very comfortable posting 508 compliant documents so that those who are disabled who want to see standards will have access to that, or a JAWS reader. The private community and the SDOs are not as familiar with that because they haven't really ever had to convert technical schematics into 508 compliant documents. And that was something that I think we learned. And from a policy perspective, we didn't want to say, oh, we're done. It's all available and it's transparent, and we've excluded an entire segment of the population who may very well want and need access to these documents as well. And then lastly, the small business community raised some interesting topics both at the July 13th PHMSA forum and thereafter, that they actually didn't want the standards for free from the SDOs. They felt that they were better off paying a nominal fee, either based on their size or based on a nominal membership, I guess upfront membership fee in the SDOs, than getting them on for free on the back end, because today they get to participate. And I think Carl said it's predominantly some of these organizations only have industry. We attend, the government across various government sectors actually attends many of these SDO technical meetings, as do a whole host of other stakeholders, academics, et cetera, that I think Elena explained. But one of the things that the small businesses said was, we actually like to participate because we want our voice to be heard on the front end. We don't want to be drowned out. And if we don't get if we don't pay for the standards on the front end, we are concerned that we'll be excluded because the fees for admission and the fees for participation will go up. And that's something that we hadn't thought about. I don't know that the SDOs have a common perspective on that. Some of them do allow free participation, but some of them do say that the reason we can give everyone access on the front end is because we sell our standards, and that helps us to subsidize the cost of these meetings. One thing that is not up and in a legal, financial, practical policy or international bucket is what some have been calling the race to the bottom. DOT didn't come up with that phrase, but the federal minimum, the federal pipeline safety laws are a minimum standard, as you all know, and the states then adopt those. And one of the concerns raised, which is very legitimate, is if the federal minimum pipeline safety laws start to get very far behind on its technical standards, meaning we stop incorporating them because an SDO refuses to post them on the web for free, or can't because its business model may not support posting free of charge on the internet, and we cannot update the standards that are currently used, what impact may that have on safety? Currently, we update our rules every 2, 3 to 4 years, and in that cycle is a regular cycle of updating many of the technical standards, some non-technical as well. And that cycle, it mirrors the SDO's cycle roughly of 18 to 36 months of updating their own standards and incorporating new advancements, learnings from accidents, and the like. So the states have said, well, that's interesting. If you don't keep those up to date and we're adopting your federal minimum standards, then the further behind you get in incorporating new standards, PHMSA, the further behind we may get in having the same level of safety requirements. And I thought that was an interesting observation from the states and others, because I think we had been so focused on the intellectual property issues, intellectual property, we hadn't really thought about what the impact would be if we stopped updating a particular standard because it was no longer available or didn't meet Section 24. I'm going to skip some of the statistical information because I think so many of you, and I'm sorry for the webcast folks, we had several hands go up about the July 13th webcast. So many of you saw this already. PHMSA has been incorporating standards since 1970, beginning with its first rules. We do send, as I mentioned, 20 subject matter experts on both sides of the house, PHMSA and the hazmat side. And it's 65 standards currently, but the good news is 20 are currently available for free. And as Helena mentioned, after our July 13th workshop, we received feedback from many of them that they would include a commitment to us in the upcoming meetings that their standards as of January will be posted for free. So some of our possible solutions, I'll talk about what we've come up with and quickly address one point that Carl made, which was one of the options is just to pay for these, and I think for a host of reasons, as I've mentioned, with the looming fiscal cliff that we heard about this morning, it's probably a tough sell. I mean, we've been trying to get a budget for more staff and more enforcement personnel, and so it was not contemplated before the Pipeline Safety Act that we might need a few million to $100 million for licensing arrangements. And I think several people have raised really good points about what kind of position does that put the government in, being sort of held to a licensing arrangement that at some point you negotiate these agreements, and there's no necessarily ironclad way of assuring that those fees, licensing costs and licensing arrangements wouldn't waiver. And we'd also have to incorporate the costs of SDOs, sort of maintaining those. So that's not, I think, at this point, a position that's probably tenable with Congress. So we haven't really pursued that. But from an operational solutions perspective, one of the things that the SDOs have come up with on their own is having portals on their website that we might link to that allow a user to register. You register, put in your name, explain, what you need, have a link to the PHMSA regulations or the regulations that are incorporated, the technical standards that are incorporated by reference. You could read only. Some, I think, allow printing, downloadable, but the SDOs would manage that rather than having the government create a portal. So that's one operational solution. Another was to have, I think, a legislative fix, a legislative amendment. Several folks have proposed anything from a complete repeal of Section 24, which I think many of you heard already. That is not DOT's position. Some of our stakeholders raised that. But anything all the way through to just an extension beyond January 3rd, 2013 as a compliance date to give any of the remaining SDOs an opportunity to figure out how to post these standards and make them accessible, and to the extent they need to, make them 508 compliant. Or at least more accessible. They're not subject to the 508 compliance requirement, but we're hoping that they'll figure out a way to try to make the schematics and drawings available to relevant audiences. So lastly, we thought maybe there's a combination of things, which could be a legislative fix that gives a small extension, but continues to have the basic tenets of Section 24 completely unchanged. We think it's a good idea to make standards that affect communities as well as that are governing the regulated entities for whom we exercise oversight available. And we had been thinking about this for a year. I think Section 24 pushed us at a much more aggressive pace, which has allowed us to get a lot of feedback very rapidly as to how we might implement this without violating executive orders, other statutory requirements, the SDO's intellectual property rights, not excluding various communities that hadn't really been at the forefront, like the small business community or the disabled community, and making sure that we don't, as PHMSA, take on something that we won't be able to execute really well, which is writing standards on our own and incorporating the SDO process into our particular agency. So with that, because Carl has this really wonderful time-elapsed clock up here, that's why I'm talking really fast. It makes you a little nervous. That we are going to continue to report out to all of the stakeholders. Our website, which has a replay of the webcast and will until next July, is going to be the place where we ultimately communicate with all of you and anyone else who is interested about what solution do we ultimately reach in January. I can't tell you that it'll be a perfect solution. This is a very complicated issue, and we have been learning along with not only all of you, but learning along with the SDOs and parsing their business models and parsing the different types of standards and the different types of costs and creation. Many of these are free, so that's good news. But for the ones that are not, I think we're going to have a very short timeline to figure out some kind of reasonable solution between now and January. So more to come on that, and please make sure that you continue to look at our website. Call me. I think I put my information here. Whoops, too far. And or email us, because it is a moving target, and we haven't worked it all out. But I do think if we can get to a point where at least the ones that are currently available for free are linked, and the SDOs who have committed to doing that can tell us when and under what circumstances they're going to do that, we'll be happy to communicate that out.